want to base my submission based on the letter sent us and which we responded on, and the response is based on the 5 items in the letter, and we also included for further guidance to the committee our Act, the National Lottery Act 2005 and the National Lottery Regulation 2007, license and permits requirements as far as the National Lottery Regulatory Commission is concerned, sports lottery regulations and requirement revised also 2017, and we also included proposed regulations on remote gaming, lottery equipment, and lottery equipment supplier. Regarding the responses that we have provided, as per the 5 items we were required to respond on, I think item 3, basically, even though we have responded to all the questions, but the one that majorly affects the Commission is the one asking about to assess the tax compliance status and remittance of other statutory contributions to relevant government agencies by service providers. And in that response, we provided thus. It is our considered assessment that service providers engaged in lottery activity are not proper and or adequate, are not making proper and or adequate statutory remittance to government. The National Lottery Act 2005 requires lottery operators to establish a prize fund and deposit 50% of gross lottery proceeds for payment of prizes. 20% of net proceeds are to be remitted to the National Lottery Trust Fund to be used on public good causes projects in sports, health, education, and other approved areas. By implications, the operator is left with a 30% share. However, the Nigerian telecommunication companies, Telcos, take as much as 70% of gross lottery proceeds when conducting lottery schemes. This is inconsistent with Section 24 of the National Lottery Act, which makes provision for the prize fund and the statutory remittance of lottery proceeds. In this respect, it is to be noted that the Telcos do not directly engage in lottery business. This is left to the third-party agents who provide lottery content and lottery scheme on the telecom platforms. However, the Telcos have a significant impact on the lottery industry and Nigerians. The Telcos fee charged to its lottery agent causes them to under-remit statutory lottery remittance, thereby circumventing the law and should charging Nigerians. In this respect, therefore, it is our opinion that immediate government intervention is needed to correct this fees anomaly and ensure strict compliance with the extant laws. And another issue that is related to what I have just said is an MOU between the National Lottery Regulatory Commission and the NCC, which is lingering, if I can use a word to qualify the situation. So there is a strict need to effectively implement the MOU so that the National Lottery Regulatory Commission can get adequate revenue that it is required to get from the telecoms. So other responses, maybe I will not take much time of the committee to read it over, but we have provided all the necessary responses, and we have expressed our opinion as the agency, which will now empower the Commission and gives it more opportunity to generate revenue for government, so that the revenue that is generated will be used according to the stipulation of the Act for the good causes and the provisions of those services, mainly on health, education, and others for good causes. Thank you very much, sir.
Thank you very much for your submission.
Profit sharing based on lottery that is carried out by telcos. You made us understand that 50% is supposed to be for the winners, 30% is supposed to be for the service provider, and 20% is supposed to go to the lottery trust fund. And you mentioned that there is non-compliance, hence there is a shortchanging the Nigerians, really, of very needed income and revenue. Am I correct?
Yes, sir.
Okay. What I want to find out from you, as the regulatory agency, I presume that at any point in time they want to go for any of these lotteries, they seek your permission, isn't it? They carry you along. Yeah. In the past, if somebody is not complying with remittances that are structured, I mean, have you in any case prevented a fresh approval of lottery? Because I would think that is the first step of compliance, of enforcing compliance. Have you, for instance, if somebody does a lottery and does not remit appropriately, have you at any time denied them subsequent request for lottery or anything in that direction? That is the first question. Then the second question is this: what platform of infrastructure do you have that correctly assesses what goes to whom? Because if I understand very well, most of this is all digital-based. So what platform of infrastructure does the regulatory agency have to determine? Because you made a submission that rather than we told 30%, most of these agencies are holding on to up to 70%, which I think is just, denying even winners and the nation some level of percentage. So, but I want to believe that this is coming from, infrastructure of measuring or assessing what goes to whom. So can you intimate us on what infrastructure, what platform of infrastructure that you use to determine the veracity of compliance? Thank you.
And I would want you, sir, to take note that the operators do not have platform of their own. They have to use the telcos. And the telcos used to charge them 70%. So they are virtually left with only 30%. And it is from that 30% now, the 50, the 20, and the 30 will be shared, because they don't have the platform of their own. So that's why the telecom operators, the telecoms are taking advantage of that, and that would even compel us to enter into an MOU with the NCC, who is regulating the telecoms. So much so that the problem that we are encountering, or the service providers or the lottery operators are encountering, in running their own scheme will be now solved. I think we have gone very far, and we had very useful discussions and resolutions. But the only problem, like I have earlier highlighted, is the implementation or the non-implementation of the MOU, which is still lingering. And we believe if it is implemented, it will go a long way to solve our own problem. And we have so many, even some cases. That's why I'm together with my legal advisor, who is the deputy director, legal in charge of our legal unit, because we have to even go to the extent of taking legal actions to the deviant operators, so that we now legally compel them to comply according to the stipulated rules of our own act. That's why we are having so many litigations bedeviling our smooth operation. So with the permission of the chairman, because part of the questions, sir, that you have asked me is talking about some legal aspect. And if the chairman allows that, I will direct my legal advisor of the commission to speak on it, sir.
Distinguished members, just to add to what the acting DG has said, our problem with telco compliance lies with the scope of our regulatory authority. We are mandated by our act to regulate the operation and business of the National Lottery in Nigeria. We don't have a direct regulatory authority over the telcos. We are aware, as we've included in our answers, that they participate in lottery activity. They do not do so directly. They do so through third-party agents. When the third-party agents come to the commission for a permit, if they comply with the requirements of our extant laws, we issue them a permit. We have no control over the contractual terms that they have with the telcos. That is why we've approached the NCC to assist us with this. But again, we cannot interfere. All we can do is lobby and let the commission be aware, that is the NCC aware, and the telcos, that they are in violation of the law. But we cannot punish innocent agents who come and apply for a license. As to the second question in relation to whether there's a monitoring or how do we assess them, erstwhile we've been assessing them through good faith reporting, which we've understood for long that cannot be an effective means of measuring compliance or the measure of compliance. So we've developed an in-house capability that we call the STRAMAP platform, which is able now to link directly with the telcos and actually measure the activity, the lottery activities that they're engaged in. What we would like is, again, the assistance of government to ensure that if our extant law says 20%, that once we measure this 20%, that we are actually able to recover that, notwithstanding the contractual terms that they engage. We believe that those contractual terms are onerous and they're in violation of the law, and that something needs to be done. Thank you.
The Lottery Act that specifies the distributables, that's the 30, 20, and 50%. Did it say net revenue or the gross revenue? That's the law. Then number two, did your law specify anything about the third party coming in? Because from what we are talking about now, there is a third party, the telecommunication companies, the agents, as a third party coming in. So is there any provision in that law that takes care of the third party? That if an agent comes in, how is he going to be compensated? Because definitely, if he is coming in as an agent, he must make also money for himself. So if you are distributing 30, 20, and 50, that means the agent is not taken care of within this distribution network. So how can it be if it's not taken care of? How do you think it can be taken care of? Thank you.
That you've painted is exactly the problem, because the agent finds himself crushed in the middle. And that's why I said it's an innocent agent. Our laws say gross. So the 20, and the trust fund is here to assist us with that answer. Assist the agent that was created alongside with us in 2005, and the National Lottery Act is here. They are actually collect the remittances that are due to government. So, but it's clear, the law is clear on one thing, that there's a percentage that is due to government. And that percentage that is due to government is taken right off the top. And the agent, when he has to enter this, because the telcos have a stronghold over the platforms that they control, obviously that they dictate the contractual terms by which they engage the lottery agents. And I believe that's unfair. I understand that they have cost, but then we also have the innocent agent, as you've pointed out. An MOU since, I can remember it since 2012. And we don't believe, well, it's my opinion, that particular MOU has not been sincerely implemented for one reason or the other. We've had several meetings with NCC, and you know, the level of their cooperation, to my mind, hasn't been where it should be, because we are the same government, and what we would like is full disclosure as to the actual activity that's going on, especially as it relates to these promotional lotteries and other lottery schemes that are happening on the platforms.
Sorry, I have to interrupt you. I just want you to tell me to tell this committee
Was to collaborate with exchange information and collaborate with NCC as a way to ensure that our and their laws are complied with. So it's supposed to be a forum where we can exchange ideas, exchange solutions, and to assist government to recover what's due to government.
Regulate the telecoms. And the problem our operators are having is with the telecoms, taking high percentage and leaving them with little. The little from which they are expected to pay the government 20% good proceeds. They pay the price from there. They retain their own share, and they now send the percentage to government. So we felt that since the NCC is regulating them, maybe with its intervention, it will go a long way to solve the problem that is causing the difficulty by the Commission as a regulator, and also the operators, that is who are holding our own permit and license and using the platforms of the telecoms. Thank you, sir. And interact with committee that is oversighting us, both the Senate and the House, looking at our own act, because it is making it very difficult for us to operate very successfully or very smoothly. There are certain lacunas identified. We've made submission to the House of Rep Committee oversighting the Commission, at a different time, and we believe they are doing so many things. Some have done, and at our own level as well, we have to have a committee that brought the commission, the trust fund, and the supervising agency, that is Office of the Secretary to the Government of the Federation. We sat at different levels and at different time with our own lawyers and the lawyers of our supervising agents to make corrections as regard to the gray areas of our own act, to the act establishing the commission. There are so many gray areas that has been identified, and those two committees that worked on it, sincerely, up till the moment I'm now speaking, are yet to come out with something that will salvage the situation. But I will equally indulge with the authority of the chair, my DD Legal, who has been part of that committee, and also the lawyers. Director of Operation, have you come with your? No, he is not here. They have been working very assiduously on it to address these gray areas. And I believe maybe he can shed more light to question asked by the Honorable.
Thank you, Chairman, distinguished colleagues. Acting DG, the question put to you by Dr. Kornike, because I don't believe in saying innocent agent. You have not exercised the powers given to you by the act. Yes, I agree. If there are lacunas somewhere, you could come up with an amendment. But what the act has empowers you to do, you have not fully exercised it. Sir, if somebody comes to you for a permit, and you know that that particular person has run foul of the law, has not complied with the law, because he or she has failed to make remittances that should have come to us, for you to also go ahead, hiding under, wow, he's an innocent agent, we don't agree to that. Yes, the NCC is there. They are there to regulate the activities of these telecos. But you, sir, once it comes to promotional lottery, once lottery is involved, then you come in. And if you know, just because, or just for what you have told us, that they have been circumventing the law of this country, and you still go ahead to issue permits and approvals for them to carry out these promotional lotteries, it is not acceptable to us, sir. And he has said, since you regulate these promotional lotteries, and you know that they have not been complying with the law, why do you also allow them to go on with these promotional lotteries? Because Nigerians run after these promotional lotteries, and they make a lot of money from it. And when they make these huge sums, they don't remit back, they don't comply with the law. So I want you to explain to us more why you still give them permits to go on with these promotional lotteries when you know that they have not been complying with the law. Thank you.
Sir, let me make it clear, sir. You satisfy our own requirement. That's why we have put it for the committee to go through and see our own requirement before we now issue with a permit. What we are saying here is this. The problem that operators are facing, because when they are asked to pay 70% of the total revenues they generated, then they are left with only 30%. That's why they now make under remittance. Because if they are not given that high charge, we are going to get high amount of money to be remitted to the National Lottery Trust Fund. We don't, normally it is only when you comply, when you are satisfied with your application, and when you all the requirements that we have established, that you follow it accordingly, that is when we give you the permit. But the complaint is this: because major promotional lotteries are done on the platform of the Telcos, and the Telcos are now capitalizing on that to make very high charge to the operators. We are invariably appealing on behalf of the operators because of the high charge that they are given by the Telcom, so that we get, they get more, and from them we equally get more to the trust fund. That's why we talk about it. But when you didn't satisfy our own requirement, we don't normally issue with permit. And when you default, we have the authority to withdraw, and we withdraw if. But this is a general problem that is affecting the industry. A joint effort between the regulator and the operator. Government is a regulator through the National Lottery Regulatory Commission. And the operators are those that are holding our own license and permits. And they have to use a platform to do their own scheme. And in using the scheme, because they don't have the platform of their own, nor do we have the platform as well. That's why
I think we'll just take the last question. Like I said, we're not supposed to take much of your time. You submitted your document, we'll study it, we'll get back to you. Just take the last question and you take your leave.
I don't think there's anything wrong holding brief for the operators, because what I see now is a situation when the law was, when the act was made law, it did not envisage lottery working on the platform of telcos. Lottery was lottery. So now that telcos have the platform, and it's a global thing now, that's where lottery takes place. But what I was expecting, and that was why Chairman was asking that question, what I was expecting was that your MOU with NCC will have addressed that gray area. I thought you will have agreed with NCC on how NCC can intervene and regulate so that whatever it is that the telcos will be charging will not jeopardize the law. And that is what I thought we'll get, and that's why Chairman was asking that question, you know. But the truth is that the nation is being short-changed right now, terribly short-changed, and I guess when we study, like the Chairman said, when we study what you wrote, I think we'll have to come up with a way forward. Chairman.
DG, you may take your leave now. We'll write you and tell you when next to appear before this committee.
This is very limited. Our mandate is really more of our role is really to protect consumers, essentially prevent violation or exploitation of consumers, and when that occurs, to provide remedies. One of the ways we do that is to monitor and enforce standards. We generally do not create standards for goods and manufactured products. The Standards Organization or some other sector regulators like NAFDAC. And for services, each sector regulators, whether it's the Civil Aviation Authority or the Electricity Regulatory Commission, or in this case, the Communications Commission. We do have relationships with all these other regulators with respect to improving standards and also providing remedies to consumers. Item V, item 5 of 2, Roman numeral 5 of 2, says determine whether there is adequate enforcement for non-compliance by relevant agencies of government. With respect to consumer protection, it's an ongoing thing. We're enforcing as much as we can. We're collaborating with the consumer protection units of the different enforcement agencies, such as the NCC. And I would say that there's still quite some road to travel. But from the record we have, we've traveled quite some road already. If there are any questions, I'd be happy to take them.
How will I say? You are the one that is supposed to really protect our interest as consumers, and I believe very much so that your organization is poised to do that. But let me just ask a very frank question. From the records that are available to you, where are we, in a grade of 1 to 10 on quality of service by telcos in this country? Where are we?
One of the key areas where there were significant complaints. But what you find interesting is that in the past year, from the records we have, the complaints to some extent have gone down. However, the issues remain. The key issues continue to be, to some extent, service quality issues and whether people are getting services they've paid for, especially when calls are dropped or when calls are terminated. And then other issues such as unwelcome and unsolicited messages and charging excessively for that. So I would say that the Commission, the Communications Commission, has done quite some work with implementing service standards, although I agree that the standards are still relatively poor. But recently there were fines based on service standards. I think finally hitting the bottom line, or at least the pocket of the service providers, ultimately created some of what we consider the improved services. I think that there's still a serious congestion issue, and there's absolutely no question or any excuse that consumers are not getting the best possible service, even when they are paid up for. And what we are doing is to strengthen our understanding and mutual cooperation with the NCC. And they have a very broad-based consumer protection approach, but we have a very specialized consumer protection approach. Our entire infrastructure is for protecting consumers, and we're deploying that and making it available to the NCC and strengthening our memorandum of understanding with them. The one big thing that we think continues to be a challenge, and which we would hope to be able to address, is that we believe that no matter how much the penalties that operators are held accountable for, until they are held accountable directly to the consumers, we're not likely to see significant improvement in standards. So there has to be a way where the operators are accountable not just to the regulators, but to the consumers, meaning that there must be a way for them to compensate consumers for loss of value and lost time. When that happens, the matrix for calculating penalties is much clearer and much more empirical, because it is returning money to those who have paid for a service that they did not receive. I suspect that it will be much higher than any penalty that could be levied against them, and it will certainly be something that improves competition and improves standards. I hope that answers your question.
Yeah, anyway, you have... And, I know that the CPC is the only saver for the Nigerian public. Now, I want to volunteer an information that I don't know whether you're aware, but the NCC has tagged this year as the year of the consumer. And I know that, yes, you mentioned something about penalty, but just like you rightly said, that's another angle. Penalty answerable to the consumer is a very key point. But I also want to point to you, the information is that what they were penalized about was actually for lack of registration of SIM cards. It didn't relate to quality of service. And that was not, it didn't have a direct bearing on the quality of service, given to people. But I can also say that I think the NCC is poised now to now give, to met out penalties based on quality of service. And I think until we start that, then it can now dovetail into refund to those that have been denied of quality service. But I think we should also, first of all, start it from the point of even, making sure that they are all accountable for even quality of service. Then it can dovetail, and that will be when Nigerians will get the best offer. It can dovetail into refund for inappropriate service or compensation to the consumer. I just wanted to share this information. I don't know whether it will help.
Thank you very much, Honorable Member. Indeed, you find a significant amount of money for not registering SIM cards. But prior to that, approximately, I want to say it's at least more like 24 months ago, the NCC came out with quality standards, and so they were measuring. And so I remember at least 2 operators were fined significant amounts of money of that. So that's the one I was referring to. But you're entirely correct. I mean, until we can benchmark those quality standards to be the appropriate grade of standards, and then police those standards appropriately, like you've mentioned, and act very swiftly with ensuring that any violation of those standards receive the appropriate sanctions. And then, because at the end of the day, any poor quality of standards ultimately hits the consumer's pockets. And so until we make sure, because when it happens, it promotes competition when you make one operator pay consumers for what they've done wrong. It promotes competition and it promotes efficiency. And I think that that is one area where we must collaborate across the board. And I think that there's an opportunity to do that now. Thank you. Or civil penalties. There's one aspect where there's a penalty, and it's punitive for your inappropriate conduct or your failure to reach the appropriate standards. And then there's a second part of reimbursement for injury. The injury is what the consumers suffer. So the penalty you pay to a regulator, whether for failing to comply with the appropriate standards, is something that makes you, in the future, not do that again, and also serve as a deterrent to others in the industry. However, what you pay to consumers is a reimbursement for the injury they have suffered. It also has perhaps the intended consequence of also improving standards. But it is also as important that you're reimbursing them, that you're improving standards also. So there are 2 different payments.
Thank you.
One agency that has to deal with everybody, because every service provider or manufacturer has a sector regulator that has to balance the rights of consumers against the rights of the operators. We have only one constituency, and that is the consumers. So we have to engage every single one of them. And what you said is typical of where you have overlapping regulation. To the extent that we're more cooperative, nothing will slip through the cracks. Because what my law doesn't cover, the sector law covers. What the sector law doesn't cover, my law would cover. And so it is that partnership that makes sure that you have all the powers that we need to regulate appropriately. And we are certainly engaging sector regulators. Thank you.
Thank you very much.
Financial Reporting Council, we are a knowledge-based agency that is involved with what initially I would have called setting of standards for financial reporting. I use the word initially. In time past, up till about 2012, we used to be a standard-setting nation where we had an agency, then the Nigerian Accounting Standards Board, that became FRCN, that develops accounting standards to be complied with by entities in their financial reporting. But then from 2012, we joined the global, as it were, converged into what we call the International Financial Reporting Standards. So at that level, whatever is set by the International Accounting Standards Board, we defer to it and try to ensure that that is complied with in Nigeria. Now, the effect of that perhaps brought out the need for us to do some learning. So what we have done in the last couple of years as Financial Reporting Council in the area of non-compliance is to allow for a time where entities can actually learn the requirements of IFRS, as it is called, as an acronym. It makes so much demands on entities. So what we have done over the years was to start off with what we call IFRS readiness, whereby entities that were adopting the International Financial Reporting Standards as their reporting framework, we demanded for some documentations from them to at least be able to midwife them into the new reporting framework. Now, to that extent, we allowed a couple of years, 2013 down to 2014, and then from last year, looking at 2015 financial statement, we've been going through the submissions made by various organizations, of course, including the telecommunications entities. What we also did as an organization was to try and do some bit of groupings. Our first focus was on the listed entities, which we thought in our own assessment were those that have public accountability directly. Recall that most of the telecoms entities, they are not listed, they are all, as it were, private entities. So from there, we are now going to the aspect of looking at those that are regulated. Of course, one of those regulated group is the telecommunications sector. And that, in the area of compliance, we just started recently looking at their 2015, 2016 as a group. So as far as the issue of compliance monitoring is concerned, we will see the aspect of the telecoms and all that as something that we are just going into currently. Like I said, we had done the grouping starting with listed entities as those that are quoted on the stock exchange, and then now we are looking at those that belong to the regulated environment, one of which is the NCC. So looking at that, we can also say at least the few that we have had opportunity of going through, especially the providers, the service providers. From what we have gone through, of course, we can say the issue of complying with accounting standards, financial reporting standard, of course, is fair if one can use that as an assessment. But then, like I said, we are a knowledge-based institution, so the issue of remittances is not much like an area of focus. In our Act, we have a provision that gives us what we should charge, but it is just like, it's something that is definitive. There's a range of turnovers within which any entity that falls within that range of turnover is expected to pay. And then if you go through that range, at the very highest, and that is where the telecom service providers come in, the highest amount that we could get from any entity, no matter the turnover, once it is beyond a certain level, is just ₦1 million. We've tried to demonstrate that in the little response that we gave, trying to analyze how much we can get. So ours is not really focusing on remittances. Of course, in due course, when we would have done the issue of reviewing their financial statement for compliance, there is also the aspect of sanctions, just like the gentleman before me talked about. There are sanctions that entities who do not comply with our standards the way they should are expected to pay. For now, we've not started applying that because, like I said, we just entered into a new financial reporting framework, which we are still allowing ourselves to learn. I think for the Financial Reporting Council, that's the bit that I can quickly put across to the committee. Thank you. On what we call international financial reporting standards, there are accounting rules that entities preparing financial statements are expected to comply with.
Can you say you've come across over the years? Are you comfortable with the status of I would say taxes and levies that are payable by the telcos vis-a-vis their earnings? Do you think they've been fair and they've been good corporate citizens?
Do you want to do that? Because I try not to preempt our findings, but so far, from what document we've received, you are not doing your job. To be honest with you, you are not doing your job. Forget about the presentation you are making before this committee now. You are not doing your job. But I'll let you take the questions that you received from my colleagues. And that's why I ask you, do you want to take some of these questions on behalf of your boss?
On the issue of access to the books and all of that, I think it would be nice to also know where our job starts from. Now, in the whole process of financial reporting, there are those that are expected to have carried out certain functions. Of course, we know that the entities themselves are expected to be the ones to at least own up to the financial statement that they have prepared. Between them and the regulatory agencies, whether primary or the Financial Reporting Council, we have the external auditors. So at the time we are getting any document, it is expected that these other people would have gone through it, including the primary regulators. And for us, sir...
Well, probably you don't understand the word reporting. You don't. You keep using words, other people. Report standard, you made reference to global practices. Is that not what you said?
Yes, sir.
You know how they report over there, don't you?
Not necessarily how they report over. The International Financial Reporting Standard as our own standard. There is what they call the generally accepted accounting practice. Initially, we were a standard-setting nation whereby we set our own standard as it suits us. But because of globalization and the fact that the world now is seen as a global market, of course, the issue of comparability and all of that, there was need for us to enter the financial reporting chain as it relates to global practice. So we adopted a system of financial reporting that makes our financial statement comparable anywhere in the world. So when you said what is our standard, that is now our standard.
Can you switch off your mic, please? I don't intend to be rude, but if you've been doing your job, most of these people here won't be here. Most of these things would have been sorted out. So you're going to take your leave now, we'll write you, and I want your boss to come before us. Your team, I want all of you here. So you may take your leave.
Again, Honorable Chairman and members of the committee, NLPC received a letter from the committee asking it to provide information on the details of tax holiday and pioneer status granted to telcos, and our response was exactly in line with the information that was requested from us. We responded providing two attachments. The first one, a list of telcos that have been granted pioneer status by the Commission from the inception of the Commission in 1999 to date. And a second attachment providing the Commission with some information on the process that applications go through in getting pioneer status. Essentially, we stated in the letter that 3 agencies are involved in the granting of pioneer status: NIPC, the Industrial Inspectorate Department of the Federal Ministry of Industry, Trade and Investment, and the Federal Inland Revenue Service. NIPC grants in principle application to companies. The Industrial Inspectorate Department determines the date of commencement of operations, which effectively forms the date that the pioneer status holiday applies from. And then FIRS administers the tax holiday and puts in place a mechanism to check abuse. So we provided a summary of the process. And then NLPC engages the others. They interface with the agencies at different parts, but it starts with NIPC. NIPC issues the certificate, based on the advice of IID, the Industrial Inspectorate Department, and then FIRS implements thereafter.
Okay. I think this tax holidays has benefited this country.
speak to the extent of the quantum of the benefit, but has given an incentive to telcos to establish in Nigeria, benefited the country? I do believe so. If you look at where Nigeria was before we had, if you compare even the number of telephone lines and the quality of telco services available before we had the telecoms revolution, and if we consider all the third-party, ripple effect of the development of the telco industry, it is difficult to separate in many ways a lot of the development that Nigeria has benefited from the contribution of the telcos. I'm not speaking about the quantum, I'm speaking only qualitatively here.
Okay, can you just, lastly, my question.
Emerging Market Telecoms Limited is the name of the company. And I believe it was granted pioneer status in line with the agreement with the government.
That means the big telecom companies now have finished enjoying their tax holidays. Is that true?
I believe they should have it.
They have. So they are not enjoying any tax holiday anymore.
Pioneer status.
Pioneer status.
Yes.
And what of tax holidays?
I can only speak to pioneer status. It's the only holiday that NLPC grants.
Okay. So who grants the tax holidays?
I'm not aware of any other tax holiday. I was just making a clarification in relation to pioneer status.
Okay.
You're with the government.
Actually, there were 4 of them. You have MTN, Etisalat, Globalcom. They were all part of the license they signed. We didn't even grant them. We only operationalized the Federal Executive Council's approval of the pioneer status for them to be granted. We only operationalized it. We just took it through the administrative process, but they didn't start with us. It was all part of the license that they were granted to operate in Nigeria.